Hi, I'm Greg Dell, and I want to talk to you about private disability insurance claim denials, and specifically, I want to talk about the options that are available to you if the claim has been denied. And today, Cesar Gavidia is here with me, and Cesar, I want to get right into this because the person who's watching this particular video is saying, look, I feel like my claim is going to be denied, or it has been denied, and what can I do? Because they're going to call their lawyers or look up things and they're thinking, oh yeah, we're going to sue them, we're going to do this and that, and we're going to crush them. And sure, we can do all of those things if we need to sue them, but lawsuits take a minimum of a year and things like that. But there's other options. So I want to talk about that first and why we're in a unique position to be able to offer those other options to a potential who's been denied versus, other people who say, let's just sue them, when that's not really what those other law firms do.
So when we think in terms of the options and the remedies available when a claim has been denied or they're about to be denied, the ultimate kind of means of the end is the lawsuit. Because once you do that, you're going to be on a timeline that's basically provided by the court. And they tell you, this is when this needs to be done, this is when you're going to be in trial, this is when discovery needs to be conducted. So there's this timeline which, like you said, could range up to a year. It could take possibly longer. And even assuming that a case goes to trial or to judgment, you still have to consider appeals and things. So these cases could drag on years. We've seen cases that they may have started in 2014 and are just being finally adjudicated and decided now. And that's 4 or 5 years later. So that's a very, very long time for someone to obviously be working their way through the legal system with their disability claim, and a very long time to be without benefits. So one of the unique things that we offer are these options when a claim has been denied. One of the first things that often we consider, or especially if there's additional information that we would want to submit, or if we feel that there's certain things lacking from the claim, is possibly going through an appeal with the insurance company. Okay, particularly with individual cases, although you see them almost in every group disability case in an administrative appeal process.
Well, in those, they're
mandatory,
right?
So, but in individual cases, they're sometimes offered, or you could request one.
Right, and so that's the first basic option, to say, hey, look, we're looking at your claim denial, and can we do anything else before we file a lawsuit? Now, often when someone comes to us and we haven't represented them ahead of time, we very often want to do some kind of additional appeal because of the fact that we may not feel that there's enough evidence in the file right now to make the claim as strong as we want, and we don't want to file a lawsuit and then try to build the file, because it's a totally different dynamic, because then the claims person and the insurance company has an opportunity to look at the file, and then when you go to depose the claim person, they say, well, we never saw that information. You never gave us the opportunity to evaluate that.
Right. And one of the common scenarios where you would want to actually seek an appeal or seek to provide additional information is when one of the more common reasons for denial occurs when one's own doctor possibly expresses limitations that fall within putting that person back to work, or they say something along the lines of, I don't think that this person's unable to work. And that may be an incorrect opinion, and now you have to go through some sort of process to correct that. And the appeal process is one of the best ways to do that.
So we have that opportunity to do that, and we have other videos where we have discussed strategies, and certainly if anyone calls us, we will review their file and discuss what we think could be additionally added to make the claim better. But the other option that's available is to possibly engage in what's called a pre-suit mediation. And can you talk about what that is and how that can work?
Sure. So that kind of falls into these alternative dispute resolution processes where with mediation, you appear with your attorney, the insurance company appears with their attorney, and there's a third party, a mediator, that his purpose and his goal is to try to get the parties to meet at a common understanding and to reach an agreement or a settlement to resolve the case. So generally, you're not talking about rules of evidence or court procedures or anything like that through a mediation process. This mediator isn't a judge. They're not there to adjudicate the case, but they are often briefed by the attorneys on the case. They understand the facts. They understand the legal issues that, apply to your specific case. And they're there to try to give you kind of another viewpoint, a third-party viewpoint, to discuss things and issues that you may not appreciate or understand to help you reach a resolution of the case. And they do the same with the insurance company.
Right. So one thing very unique about our law firm is the fact that we've been, doing this for over 30 years is the fact that the insurance companies already know Dell and Schaefer, their team of lawyers, they can take a case all the way. They know what they're doing. We know it's going to be in excess of $100,000 probably on a defense cost to litigate a case. And we don't have to test the law firm to see whether or not they know what they're doing. So because of that, basically we can come together in a business type, scenario and say, hey, look, let's talk now instead of a year or year and a half from now when we're going to be at the same spot and see if we can get this case done. That's advantageous for our clients and for the insurance company because the clients are going to get the benefit of the reduced amount of money that the insurance company doesn't have to spend on their lawyer.
Right. That and time, because money is time. And the more time that goes by without the insured, without our client having these benefits, without having this money to pay for, all of life's necessities, their mortgage, their rent, their, tuition for their kids, everything that's necessary to get through day to day, that's obviously costing significantly as well.
And from doing this for so many years, we've built the relationships with the in-house lawyers and the representatives at the insurance companies to say, hey, let's get together anywhere in the country, come to our office, we'll come to, a location that's convenient for our client. We'll meet, we'll have a professional mediator, and let's see if we can get this thing done. And the reality is, I would say that more than 50% of the time, we're able to reach a resolution in that scenario. Is that something you would agree with?
Yeah.
Okay. So, you have trying to do an appeal, you have a pre-suit mediation. When all of those things fail, then the final remedy at that point is to file a lawsuit.
Right.
And we've touched on that process. That can happen in state court, that can happen in federal court, depending upon the amount that is in controversy, depending upon if there's diversity of jurisdiction, depending upon the case law. There's different forums as to where your lawsuit can be filed. It's not necessarily where you're living. It could be where the insurance company is. There's so many different factors that go into where that lawsuit is going to be, who the potential judges are. I mean, it just goes on and on. So choosing the particular venue is a significant factor when it comes time to file a lawsuit. And we filed these cases anywhere in the country. It doesn't matter where you're located. The other factor is, so what is a real time frame with these lawsuits? And let's assume most of them end up in federal court. So what is a real time frame that someone should expect?
Well, in most cases, you're looking at a time frame from the time you file your complaint. The insurance company, just from that point, has about 20 to 30 days to respond. And even then, their defense attorneys usually ask for an extension of time because they get retained right at the basically tail end of that time period. So by the time that they actually respond to the lawsuit, you're probably looking at 2 months have already gone by. And then you're talking about maybe anywhere from 6 to 7 months just for the discovery stage of the litigation. And then from that point, getting through dispositive motions, summary judgments, different legal issues that the lawyers have to brief for the court, you're talking about at least 12 months, possibly 13, 14 months in litigation.
And, from our strategy and our style at this law firm is we realize that as this lawsuit's pending, you're not getting paid in most situations,
right,
unless it's some dispute they're not paying enough or it's a residual versus a total disability. So we don't want to mess around with these nonsense motions that the defense would want to get into, like motions to dismiss, summary judgment motions, discovery disputes that can go on and on. We're not going to play that game with them because the more they can stall it, the longer they go without paying the claimant, and the longer it takes for us to get to the jury, which is ultimately the outcome that we seek.
Right.
So even if we go to trial and we win these trials, then the insurance company has the right to appeal.
Yeah.
And unfortunately, when it comes to an appeal, you're looking at potentially another year,
Right.
18 months before a decision's made on an appeal. And that's whether you win or lose your lawsuit. So we can obviously speak with you in more detail about the real process that goes on. It's a little bit different depending upon what jurisdiction and what company, so we would let you know about that. But there's this other thing a lot of people call up about and they want to know, and that's called a bad faith claim. And how does that play into the mix here as an additional remedy? Because most people think my insurance company denied me, therefore they acted in bad faith. Not always.
Right. The conduct isn't always, bad faith. Bad faith is a very specific legal term in most cases, and it's defined either by the statute or by your state's particular case law.
Right,
okay?
the common law.
The common law, right. And so very specific elements, very specific case facts need to be met in order to establish bad faith. Now, there certainly could be facts to bad faith in your case, but it's not something that necessarily is, it appears, or is something that is established in every claim denial.
Right, so it's certainly we've handled many bad faith cases with regard to a wrongful disability insurance denial. They're not there in every case, so don't be misled to thinking that someone you call them and they go, oh, absolutely, that's bad faith, because bad faith is a very high standard to prove, and it doesn't happen often. When it does happen, it's something that basically you think if their denial shocks the conscience, then basically it would be bad faith to simplify it. But not every state has it, and as a matter of fact, there's only, I'd say less than half the states actually even offer a bad faith statute that has any teeth to it. And then the last remedy we want to touch on is, are attorney's fees compensable for in a claim for when a claim is brought? Meaning, is the insurance company going to have to pay our attorney's fees that the client's going to be responsible for?
Right. So attorney's fees is another legal question that comes down to your particular state. In some states, if an insurance company denies you in a first-party insurance dispute, you're guaranteed bad faith, you're guaranteed attorney's fees, like in Florida. But there are other states that, they follow what's called the American rule or the common rule, where attorney's fees aren't necessarily awarded if you win. Each party has to cover their own attorney's fees, and yet there are other states where it may be given to the prevailing party. So that means that if you go to trial and you lose your case, or you go to summary judgment and you lose your summary judgment motion, the insurance company could possibly win defense attorney's fees. And I always tell people, I say, listen, the insurance company is probably in a better position to pay an award of attorney's fees than the individual person. So that's something you have to consider in terms of your risk assessment.
Right, and in the states where you can get attorney's fees and you can get bad faith, then you have more teeth and more leverage over the insurance company. In the states where there are no attorney's fees and no bad faith, the leverage is a lot lower, and now with the federal interest rates and the state interest rates on judgments, there's not a lot of incentive for these companies to move quickly on these cases. So you have to have a lawyer that's skilled in knowing how to push your case forward. So if you have a lawsuit or a claim denial that you're concerned about, feel free to call Cesar or any of our disability attorneys here. We'll always offer you a free initial consultation. We're available to help you anywhere in the country, and we look forward to the opportunity to speak with you.